2, 1.
This Honorable Court of Appeals is now in session.
Good morning and welcome to the morning session of the Court of Appeals. Your panel today will consist of Judge Armstrong from Memphis, Judge Davis from Knoxville, and I'm Judge Golden from Memphis. We have anything we need to address before we call the case, ma'am?
No, sir.
All right, please call the next case.
Tony W. Carrick et al. Versus City of Shelbyville, Tennessee.
Mr. Husky?
Yes, Your Honor.
All right.
Well,
You still need to give us your name for the record. We're recording.
Okay, thank you, Your Honor. Jason Husky here for the plaintiffs, member of the Coffee County Bar.
All right.
This case will stand out and be unique because I think it will be the shortest argument I will ever present, and definitely so far and probably going forward. The case at bar is based on a summary judgment motion, and it really comes down to three points. Did the city of Shelbyville, could it be found that they had actual or constructive notice of the safety hazard that caused the injury to my client? There are three main facts in this case that are irrefuted and undisputed. Mr. Carrick was an elderly man in Shelbyville, Tennessee. He was driving his car and had the road give way underneath him, caused physical and property damage to him. The undisputed facts in question are these. On August 29th, City of Shelbyville, a member of their staff went out inspected the specific culvert that the accident occurred at because there had been flooding. They inspected this culvert. He went through after the inspection and put in a work order to replace that culvert. And that replacement was to begin within 48 hours. It's an undisputed fact from their statements. 24 hours later, on August 30th, Mr. Carrick, driving over the road, had it collapse out from underneath him, causing damage, physical and property. Those are the three undisputed facts in this case. They knew, they inspected, they saw it, they ordered it to be replaced, and it fell through before they replaced it.
Let me ask you, Mr. Husky,
Yeah.
The inspection was because of a flooding event. What is the connection between the flooding and the culvert and the collapse of the roadway? I mean, how was the culvert not functioning properly during this rain event?
Well, the rain event occurred before. The rain event is what caused them to come and inspect it. Upon inspection, they found that the culvert was in need of replacement. The culvert is the foundation that holds up the road. Now, that they have tried to make a distinction between the culvert and the roadway being the asphalt setting on top of the culvert. But much like a bridge, if the support underneath the bridge goes out, it doesn't matter what the condition of the asphalt is on top of the bridge. It's the support underneath it. As a practical matter, the roadway, the asphalt could have been cracked all to pieces. But that's, if the culvert underneath it's in support, it's probably not going to cause any damage. What caused damage is the support fault. Yes, ma'am.
Was the road that gave way directly over the culvert that was in need of repair? Because I think I saw something indicating that it may have been a little ways down the road.
No, ma'am, it was directly over.
The
culvert
okay.
Collapsed and his car went through the hole.
Okay.
When his car drove over, it collapsed underneath him.
And I assume it's also an undisputed fact that there was no effort after they made the inspection and determined that the culvert needed to be replaced, that there was any warning or tape or cones or anything put around the culvert to indicate that it was not, that it needed repair and replacement?
No, Your Honor, there was none.
I'm sorry, go ahead.
Oh, okay. I was saying, no, there was not any cones or anything put up.
No, I'm sorry. Go proceed with the argument. I'm sorry. I got your answer. Thank you.
Well, largely, that's it. It is a very short, I can't honestly imagine much more of a situation where you have notice. They inspected it the day before. They determined it needed replacement. And it gave way 24 hours later, 24 hours before the replacement was to start. It's hard to imagine. You have, if you want to separate the culvert and the road, which I think is inaccurate because that's the support for the road. But even if you were to separate them, you would have actual knowledge of the damage to the culvert and constructive knowledge of the danger it posed to the asphalt above it. But realistically, that's the support to the road. It's all one thing. And you had actual knowledge of that damage and danger.
Did you adduce any expert proof to the effect that the problem they noticed with the culvert would likely lead to collapse of the roadway, Mr. Husky?
This was replaced. This was set for repair and replacement 24 hours after the accident. There was no opportunity for really any inspection beyond just the pictures my client had. This, I would think this would be akin to in a malpractice. You don't need a medical expert when you have they find a sponge left in the person's body or a piece of equipment left in the body. It's a common sense. You can't have much more clear issue of notice. They absolutely saw it. They absolutely said it was damaged. They needed repair. 24 hours later, it gave way.
Did they say it needed to be replaced? Is that what they said in the report?
Yes. It was set for replacement to begin 48 hours from the time he saw it.
Actual replacement.
That's what the work order says.
All right, sir. Thank you.
Any other questions?
Anything else, sir?
No, sir.
All right, thank you. You'll still have your rebuttal time.
Thank you.
All right, we'll hear from the appellee, Mr. Mazzotta.
Yes, Your Honors. Good morning. May it please the court. My name is William Mazzotta of the Williamson County Bar, and I represent the city of Shelbyville in this case. I know that we've covered some of the facts so far. Would Your Honors like a rundown of some of the operative facts on this appeal?
Yeah, I would like to know, what was the condition of the culvert at the time of the inspection, and why was it being ordered replaced? What was wrong with it?
Well, those facts aren't in the record. In order to avoid creating an issue of disputed fact, the city didn't provide that into the record. If Your Honors would like to know, I can provide that information to you.
If it's not in the record, then you can't.
Yeah.
You can't take it if it's not in the record.
Yeah, and that's fine. So
was the notice the notice or the form saying it needed to be replaced? Is that in the record?
yes, Your Honor. Attached to the declaration of Mr. Grady Frazier, employee of the city of Shelbyville, there is an exhibit to his declaration, which is an email. And that email is a work order put into the Tennessee One Call Ticket Information System. And that work order indicates that the culvert should be replaced. And although Mr. Husky is characterizing it as that it was ordered to be done within 48 hours, that's not quite reflected in the work order itself. I presume he's getting that information from the work to begin phrasing that's used in the work order. The work order, however, is not set to expire until September 16th, 2017. So, again, that fact and explaining those facts are not in the record, but I think that it's a little bit of a stretch to take that one date and therefore say that it had to be done by this date when there's other dates in the record. And I would just like to point that out.
Where would that date have come from? That it had to be prepared within 48 hours. Where did he extrapolate that date from?
So it's there in the work order, Your Honor. It about halfway down on the work order page, it states that work to begin, and then it just kind of has a semicolon or colon, excuse me, and it says September 1st, 2017.
Is that 2 days? Is that 48 hours? Is that within 48 hours?
Approximately, Your Honor.
I don't understand your point then.
Well, my point being that there's other dates in that work order that state that the work order should be updated and that it expires days after that, and that the work order expires on September 16th, 2017. So my point being that it doesn't indicate that it has to be done on the 1st. It's simply that is just a date that's on there that says work to begin. Again, we don't have those facts in the record, so.
Was that date written in there or typed in there?
It appears to be typed or perhaps even generated based on the way the report looks.
All right.
Mr. Mazzotta, as I understand your argument, I think it is that although there may have been notice of a defect or a need for repair or replacement in the culvert, are you saying that because the actual road above the culvert was not reflecting any damage, that your client did not have notice?
Yes, Your Honor. So in back to Mr. Frazier's declaration, and the only facts in the record that relate to this issue are the facts that were provided by the city. And that declaration contains Mr. Frazier's testimony that states that he was not aware, or that it was his opinion, excuse me, that the culvert in its state on the day before the alleged accident did not pose a threat to the integrity or stability of the road. And that was part of the trial court's findings, that in the record, what's in the record is that the culvert needed to be replaced, hence the work order, and that Mr. Frazier had stated that the condition of the culvert one day before the alleged accident did not pose any risk to the integrity or stability of the road.
Then why would they need to replace it?
Question.
Oh, Your Honor, again, those facts aren't in the record in order to avoid creating an issue of disputed fact. But I would simply offer that, pieces of infrastructure need to be replaced regularly that don't necessarily constitute a dangerous, defective, or unsafe condition. They may need routine maintenance and routine replacement, but that doesn't rise to the level of a dangerous, unsafe, or defective condition under the GTLA. And so just going.
Was there any warning to the public about the defective nature of the fact that the culvert needed to be replaced?
No, Your Honor, and I would offer that simply indicates that this was not a dangerous, unsafe, or defective condition as alleged by the plaintiffs. There was no big warning sign. There was that isn't part of what we have here. It's simply that the culvert was in need of replacement. Not that this posed a risk to the public.
Did the road sit on the culvert? The road that collapsed, was it directly over the culvert?
Well, to be clear, for the purposes of our summary judgment motion and on this appeal, of course, the city doesn't dispute whether the accident or that the road collapsed itself or that a hole formed. But
I'm just asking I'm just asking the location. I'm not asking how it happened. Yes. I'm just asking where the location of the road was in relationship to the culvert.
Yes, Your Honor. As plaintiff's counsel noted, for the purposes of our summary judgment motion, the hole did form above the culvert. Yes, Your Honor.
Thank you. Go ahead.
So fundamentally, the key issue here is that plaintiffs need to create a link between the city's determination that the culvert needed to be replaced and notice of a dangerous, unsafe, or defective condition that caused the accident. This case, I would argue, Your Honors, is comparable to this court's ruling in McMahon versus City of Cleveland. In that case, the plaintiff failed, the court held that the plaintiff failed to establish notice, where the plaintiff produced no evidence that the raised or cracked and uneven defect in the city's sidewalk where she tripped and fell was caused by the growth of a tree root of a tree planted by the city. And so here we have kind of a similar analogous situation. Plaintiffs cannot draw a connection between the city's inspection and knowledge of the need to replace the culvert the day before the alleged incident and the alleged formation of the hole under Mr. Carrick's truck. There are no facts in the record to prove this connection beyond the inference that plaintiffs have alleged time and time again. And simply, and I'll just state it again, one issue, so the issue with replacing the culvert does not equal another issue, which is their burden to prove that there is a dangerous, unsafe, or defective condition that the city has notice of. Although plaintiffs argue and attempt to equate the city's work order to replace the culvert with the alleged hole that formed, there's no proof to support that contention in the record. In the record, as I've stated, Mr. Frazier testified that when he inspected the culvert the day before the alleged accident, he discovered that the culvert was in need of repair, but did not find that the culvert posed any threat to the stability or integrity of the road. And ultimately, that's what we're here about, is the integrity and stability of the road. That's what allegedly caused this accident. Despite plaintiff's claim that the culvert is the dangerous or defective condition, there's no proof to support that finding. There are no facts to dispute that, let alone materially dispute the city's facts related to the inspection of the culvert the day before the alleged accident. It's our position that the trial court did not ignore any of the facts in the record, rather that plaintiffs failed to substantiate any of their allegations with facts, not even a one-sided affidavit. They solely rely on plaintiffs' versions of events and inference.
How soon after the incident occurred, the accident occurred, or is this in the record? I don't know if it is or not, but the question was asked of Mr. Husky why he didn't get an expert, didn't have an expert, and he said because it was immediately repaired. Is that in the record, how soon it was repaired after the incident occurred?
No, Your Honor, that information is not in the record.
All right. What about the question of whether your inspection was simply wrong? In other words, is that an issue of fact as to, you raised the question about the fact that apparently Mr. Frazier says that this connection and whatnot, that they weren't aware that what the problem might be, perhaps. What about the fact that he may have been wrong? Was that or negligent in his inspection?
Sure. There aren't any records in the fact, there aren't any facts in the record to dispute that, though. So we have Mr.
Other than the fact that the road actually failed.
Right.
Excuse me, I'm sorry.
I'm not trying to be smart, but other than the fact that the road actually failed, that's a fact in the record that shows that he may have been wrong.
Again, I would just offer that the connection between replacing a culvert and then taking a leap to state that therefore gives indication that not just that the culvert needed to be replaced, but somehow that inherently makes the culvert dangerous, defective, unsafe, and a threat to the road and the public that drives on top of that road. I think that is a significant leap, and that's why I'm referring to it as an inference. And there are no facts in the record that go to that point. at
Is there-
all.
Is it a fact in the record that the road sits on the culvert that needed to be replaced?
It's undisputed that as we've stated that the hole formed above the culvert. Whether the culvert, I think as Mr. Husky has kind of characterized as, it was the foundation and the way for the road to be held up. Those facts aren't even in the record.
But it is in the record that the road collapsed directly over a hole formed directly over the culvert in the road.
That is not in dispute.
All right. Thank you.
Let me make sure I'm clear about this, Mr. Mazzone. The inspection doesn't indicate the problem with the culvert, whether it was a crack in it or crumbling or any details about why it needed to be replaced. Is that true?
Yes, Your Honor. And again, that was intentionally done in order to avoid a dispute of material fact.
No, but I'm talking about what Mr. Frazier observed when he went out there and made the determination we need to replace it. What is it that he saw that led to that conclusion?
That is not in the record.
So the work order just says culvert needs to be replaced, work to begin on X date through whatever date.
Yes, Your Honor.
Okay.
And the culvert is a concrete culvert, is that right?
Again, that is not in the record.
Okay.
That being said, Your Honors, I would just reiterate that the plaintiff, that the trial court found that the city had met its burden on summary judgment on both fronts. One, to negate the essential element of notice to plaintiff's claim, and also finding that plaintiff's facts related to the issue of notice were insufficient. Thank you, and I would respectfully ask that the judgment be affirmed.
Thank you. Mr. Husky, you have 5 minutes for rebuttal. You're mute, sir. You're mute.
Sorry.
All right.
Just a couple quick things. Y'all actually picked up and addressed most of what I would have brought up. Briefly on the statement that was provided that he referenced that it did not pose a threat by Mr. Frazier to the roadway. That is a statement Mr. Frazier made a year and a half after the fact. That was not a statement he made at the time when he did the inspection or the work order. The limit of what his comment was at the time was that it needed to be replaced, and it was to begin in 48 hours. That being said, when he made the statement, he didn't think it posed a threat. That was a year and a half after the fact, subject to this lawsuit, when he knew that it had collapsed 24 hours after his inspection. And so one, it was his opinion, but two, that kind of calls into question I think the statement itself. Let's see. Beyond that, it is honestly, it's hard to imagine a situation when you're having to deal with notice where you have an inspection of the questionable area 24 hours beforehand and a finding that it needed to be replaced. I don't know when you're going to get a clearer cut version of facts than that. Short of there just being a massive hole in the ground, in which case my client likely would not have driven into it if that was the case. But we would ask this honorable court to overturn the ruling and send this case back down.
Mr. Husky, do you know anything about the flooding that occurred that led to this inspection?
Only to the extent I know my clients have stated that area flooded a lot and they had problems with flooding in that area on the roadway, not beyond that extent.
So water was flowing over the roadway, is that right?
Not at this time, no.
I understand.
they had sent an inspector out, they said, because of flooding that had happened, and they were doing inspection after that.
And do we know whether the new culvert was larger than the culvert that was there at the time of this incident?
I do not know if the diameter of the culvert's different. I know the location of the road hasn't changed, or there's not a lump on the road. But beyond that, no, we do not. I don't know the structural difference of the new culvert from the old culvert.
Okay.
That's not in the record.
No, sir.
Any other questions? Thank you, gentlemen. We'll take the matter under advisement and advise you of our opinion as soon as possible.
Thank you. Your Honor.
Thank you for your argument today.
Thank you, Your Honor.
This Honorable Court of Appeals is in recess until 1 p.m.